Case Law No. 9/2016/AL on determining average overdue interest rate on the market and payment of interest on penalties for breach and compensation for damages.
Including 5 parts, Part 1, Source of the Case Law, Part 2, Overview of the Case Law, Part 3, Content of the Case, Part 4, Assessment of the Court, Part 5. Rules.
This case law was adopted by the Judicial Council of the Supreme People's Court on October 17, 2016 and promulgated under Decision No. 698/QDCA dated October 17, 2016 by the Chief Justice of the Supreme People's Court.
Part 1, Source of the Case Law.
Cassation Decision No. 07/2013/KDTMGDT dated March 15, 2013 of the Judicial Council of the Supreme People's Court on commercial case, dispute on contract for sale of goods, in Bac Ninh Province between the plaintiff being Vietnam, Italy Steel Joint Stock Company against the defendant being Hung Yen Metallurgy Joint Stock Company. Persons with related rights and obligations are Ms. Lu T Ngoc Lan and Mr. Lu Van Dung.
Part 2, Overview of the Case Law.
Background 1 of the case law, the contract for sale of goods is breached because the seller failed to deliver or delivered insufficient goods to the buyer, causing the seller to be obligated to return the advance payment and overdue interest for late payment. Legal Resolution Number 1, in this case, the overdue interest is determined on the basis of the average overdue interest rate on the market of at least 3 local banks at the time of payment, first instance hearing, unless otherwise agreed by the parties or stipulated by the law. Background 2 of the case law, with respect to the contract for sale of goods, there arise the obligations to pay penalties for breach and compensation for damages. Legal Resolution 2, in this case, the obligor is liable for paying the penalties for breach and compensation for damages, but is not obligated to pay interest on the penalties for breach and compensation for damages. Key words of the case law: contract for sale of goods, breach of contract, return the advance payment, overdue interest due to late payment, overdue interest rate, average overdue interest rate on the market, penalties for breach, compensation for damages.
Part 3. Content of the case.
Pursuant to the Statement of Claims dated July 7, 2007, application for amendment of the Statement of Claims dated October 10, 2007, documents in the case and submissions of the plaintiff's representative. On October 3, 2006, Vietnam, Italy Steel Joint Stock Company, hereinafter referred to as Vietnam, Italy Steel Company, entered into economic contract No. 03/2006 HDKT with Hung Yen Metallurgy Joint Stock Company, hereinafter referred to as Hung Yen Metallurgy Company, by Mr. Nguyen Van Tin, Deputy Director acting as the authorized representative under the Power of Attorney No. 621 dated September 10, 2005 by the General Director of the company. Under this contract, Vietnam, Italy Steel Company, Party A, purchased steel billets JST 380-94 grade CTS 5 SP/PS from Hung Yen Metallurgy Company, Party B, with the quantity of 3,000 metric tons plus or minus 5%, unit price of VND 6,750,000/ton. Time of delivery was from 25 to October 31, 2006. The total contract price was VND 20,250,000,000 plus or minus 5%. On October 4, 2006, Vietnam, Italy Steel Company remitted the entire amount of 20,250,000,000 VND to Hung Yen Metallurgy Company via the bank wire instructions through Joint Stock Commercial Bank for Foreign Trade of Vietnam, Hai Duong Branch. Hung Yen Metallurgy Company delivered 2,992,820 tons of steel billets to Vietnam, Italy Steel Company and left 7,180 tons undelivered, which corresponded to an amount of 48,465,000 VND. On December 20, 2006, both parties signed contract No. May 2006 HDKT. Hung Yen Metallurgy Company's authorized representative who signed the contract was Mr. LUient Man, Deputy Director, under Power of Attorney No. 1296/UQ/HYM by the General Director. Under this contract, Vietnam, Italy Steel Company purchased 5,000 metric tons of steel billets, with specifications and quality are the same as those in contract number 03, unit price of 7,290,000 VND/ton, included VAT and transportation expenses. The total contract price was 36,450,000,000 VND plus or minus 5%. Time of delivery was from January 18, 2007 to January 30, 2007. Vietnam, Italy Steel Company would advance an amount of 500 million VND to Hung Yen Metallurgy Company immediately after the contract was signed. The remaining amount would be paid in 2 installments after Vietnam, Italy Steel Company took the delivery. The contract also provided for Hung Yen Metallurgy Company's obligation on paying a penalty for breach equivalent to 2% of the contract price if it failed to deliver the conforming goods or failed to deliver the goods. According to Vietnam, Italy Steel Company's representative, on December 21, 2006, Vietnam, Italy Steel Company remitted the advance payment of 500 million VND to Hung Yen Metallurgy Company. But Hung Yen Metallurgy Company did not perform the contract and did not have any reasons for not performing. On the same date of December 20, 2006, Vietnam, Italy Steel Company signed contract No. June 2006 with Hung Yen Metallurgy Company, with the authorized representative being Mr. LUient Man, Deputy Director, to purchase 3,000 metric tons of steel billets of which the unit price was 7,200,000 VND/ton from Hung Yen Metallurgy Company. The contract price was 21,600,000,000 VND. The time of delivery was from January 5, 2007 to January 15, 2007. On December 22, 2006, Vietnam, Italy Steel Company remitted the full amount of 21,600,000,000 VND to Hung Yen Metallurgy Company under the bank wire instructions through Techcombank, Hung Yen branch, but Hung Yen Metallurgy Company delivered only 2,989,890 tons of steel billets to Vietnam, Italy Steel Company, leaving 7,640 tons undelivered, equivalent to 55,008,000 VND. On February 1, 2007, Vietnam, Italy Steel Company signed contract No. January 2007 with Hung Yen Metallurgy Company, with the authorized representative being Mr. LUient Man, Deputy Director, to purchase 5,000 metric tons of steel billets of which the unit price was 7,800,000 VND/ton from Hung Yen Metallurgy Company. The contract price was 39 billion VND plus or minus 5%. During the contract performance, Vietnam, Italy Steel Company remitted an amount of 37,100,000,000 VND to Hung Yen Metallurgy Company and Hung Yen Metallurgy Company delivered 3,906.390 tons of steel billets to Vietnam, Italy Steel Company with the value of 30,469,842,000 VND. The quantity of steel billets which Hung Yen Metallurgy Company had not delivered to Vietnam, Italy Steel Company was 928,255.38 tons, being valued at 7,240,158,000 VND. Vietnam, Italy Steel Company sent a number of letters requesting Hung Yen Metallurgy Company to perform the contracts, but Hung Yen Metallurgy Company failed to do so, causing Vietnam, Italy Steel Company purchase steel billets from other manufacturers to ensure its production and business activities. As Hung Yen Metallurgy Company breached the contracts signed between both parties, Vietnam, Italy Steel Company initiated a lawsuit against Hung Yen Metallurgy Company to hold Hung Yen Metallurgy Company liable for the payment and compensation for damages due to the breaches in delivery and contracts No. March 2006, May 2006, June 2006. January 2007 at the time of the lawsuit, amounting to 12,874,208,683 VND, wherein the pending payment amounts of 11,181,662,503 VND was for 1,777,020 kilograms of steel. Billets, the amount for penalties for breach was 1,316,490,480 VND and the overdue interest was 376,145,700 VND. The plaintiff's representative requested that Hung Yen Metallurgy Company pay an amount of 28,145,956,647 VND to Vietnam, Italy Steel Company, being calculated until the time of the first instance hearing of September 3, 2009, and Hung Yen Metallurgy Company be compelled to issue VAT invoices to Vietnam, Italy Steel Company with regards to the delivered quantity of the goods under contract no June 2006 being 21,544,992,000 VND and under contract no January 2007 being 30,469,842,000 VND. At the time Hung Yen Metallurgy Company signed those aforementioned contracts with Vietnam, Italy Steel Company, Ms. Le Thi Ngoc Lan was still the general director and Mr. Le Van Dung, Ms. Lan's husband, was the business consultant. On March 22, 2007, Ms. Le Thi Ngoc Lan transferred all of her shares in Hung Yen Metallurgy Company to Ms. Nguyen T. Ton, who then became the acting general director from April 2, 2007. Pursuant to the agreement on division of property during marriage between Mr. Le Van Dung and Ms. Le Thi Ngoc Lan and the debt commitment document of the company, Mr. Le Van Dung agreed to bear all responsibilities to pay all of Hung Yen Metallurgy Company debts arising before April 1, 2007. Now Vietnam, Italy Steel Company claimed for compensation for damages from contracts no March 2006, May 2006, June 2006, and January 2007, and Hung Yen Metallurgy Company does not agree because the responsibility to compensate such damages belong to Mr. Dung, Ms. Lan, and other former leaders and managers of Hung Yen Metallurgy Company. Hung Yen Metallurgy Company proposed the court to review and re-evaluate the validity of contracts no March 2006, May 2006, June 2006, and January 2007 signed by Mr. Man on behalf of Hung Yen Metallurgy Company with Vietnam, Italy Steel Company in this case, and review the responsibility of Mr. Dung, Mr. Man, Mr. Tin, and Ms. Lan with respect to the debts requested by Vietnam, Italy Steel Company. At the first instance hearing, Hung Yen Metallurgy Company basically agreed with the numbers relating to the contract performance that were provided by Vietnam, Italy Steel Company. However, the financial data was not agreed, because the financial data have not been compared to the debt numbers. The overdue interest on the contracts needed to be recalculated. The defendant did not agree with the interest in contract number 05 because both parties had agreed to cancel the contract and transfer the amount of 500 million VND advanced by Vietnam, Italy Steel Company to perform contract no January 2007. Therefore, there was no contractual breach committed by Hung Yen Metallurgy Company with regard to contract number 05. In early 2004, she and her husband purchased the shares in Hung Yen Metallurgy Company from Mr. Nguyen Luong Tuan and Mr. Nguyen Van Tan. At that time Hung Yen Metallurgy Company was during its early development. Due to that reason, Ms. Lan became the general director and chairperson of the board of management. Meanwhile, Mr. Dung became the business consultant of Hung Yen Metallurgy Company. Due to the conflicts arising in their marriage, on September 5, 2005, Ms. Lan and Mr. Dung entered into an agreement on division of property during marriage at Hong Ha Law Office, registered with Hanoi Bar Association. According to this agreement, Ms. Lan owned the house at number 250 Ba Tru Street, Mr. Dung owned the entire 48 billion VND being the shares of the spouses in Hung Yen Metallurgy Company, and Mr. Dung had to be responsible for all the debts of Hung Yen Metallurgy Company during the early development of Hung Thai Steel Rolling Mill, which belonged to Hung Yen Metallurgy Company. Since Ms. Lan no longer had shares and had transferred them to Mr. Dung, Ms. Lan authorized Mr. Tin and then Mr. Man to manage the company. Although Ms. Lan did not own any shares, she remained the general director, but in reality, Hung Yen Metallurgy Company was managed by Mr. Dung, Ms. Lan's husband, Mr. Tin, and Mr. Man. In July 2007, Ms. Lan handed over outstanding debts and the general director position to Ms. Ton. Ms. Lan further confirmed the fact that Mr. Man and Mr. Tin, both of whom were deputy directors of Hung Yen Metallurgy Company, signed economic contracts with Vietnam, Italy Steel Company with her authorization regularly. However, when the handover of the rights and obligations to Ms. Tone occurred, Mr. Dung as well as Ms. Tone and Ms. Lon confirmed that the responsibility to pay the debts to Vietnam, Italy Steel Company did not belong to Ms. Lon. Although he and his wife had agreed to divide property during their marriage and Mr. Dung was able to own the shares in Hung Yen Metallurgy Company, Mr. Dung only held the position of business consultant without being entitled to sign any economic contracts as well as to make payment, therefore, he had no responsibility. Mr. Dung disagreed with Hung Yen Metallurgy Company's statement that he must be the one to be responsible for paying the debts. He asserted that the responsibility fell on Hung Yen Metallurgy Company and Ms. Tone. Mr. Dung confirmed that on April 1, 2007, he signed a commitment with Ms. Tone. The commitment document showed the total value of debts for both parties to finalize, and this was for internal use between him and Ms. Tone as the basis for the finalization and handover. However, there was no actual purchase of shares in the company between him and Ms. Tone. Both parties did not sign any agreement on purchase of shares and he was not aware of the transfer of shares between Ms. Lon and Ms. Tone. As for the lawsuit initiated by Vietnam, Italy Steel Company against Hung Yen Metallurgy Company to request it to pay pursuant to the contracts, Mr. Dung noted that, from the legal perspective, Hung Yen Metallurgy Company must be responsible as a legal person. He does not have any responsibility with any clients or business partners. His responsibilities, if any, were only with Hung Yen Metallurgy Company. Mr. Dung requested to be absent from all court hearings. In first instance commercial first instance judgment number 01/2007/KDTMST dated November 14, 2007, the People's Court of Bac Ninh Province ruled to compel Hung Yen Metallurgy Company to pay Vietnam, Italy Steel Company the total amount of money from the 04 contracts number 03 dated October 3, 2006. Number 05 dated December 20, 2006, number 06 dated December 20, 2006 and number 01 dated February 1, 2007, being valued at 24,674,428,500 VND. In addition, the first instance court ruled on the court fees and the right to appeal of the involved parties. On November 27, 2007, Hung Yen Metallurgy Company submitted an appeal. In Appellate Commercial Judgment Number 120/2008/KDTMPT dated June 18, 2008, the Appellate Court of the Supreme People's Court in Hanoi ruled to set aside first instance commercial first instance judgment number 01/2007/KDTMST dated November 14, 2007 of the People's Court of Bac Ninh Province. Transfer the case to the People's Court of Bac Ninh Province for resettlement in accordance with the law, for the reason, the first instance court had not collected the statements of Ms. Lon, Mr. Dung, Ms. Tone, Mr. Tin, and Mr. Man and had not determined the persons participating in the proceedings, and thus failed to determine who shall bear the responsibility to pay the debts to Vietnam, Italy Steel Company. Furthermore, other documents such as debt commitment documents, money receipts of Mr. Dung, power of attorney for the company management, are all copies without being duly notarized, certified or without being compared with the originals of the first instance court. In first instance commercial first instance judgment number 09/2008/KDTMST dated October 23, 2008, the People's Court of Bac Ninh Province ruled to compel Hung Yen Metallurgy Company to pay Vietnam, Italy Steel Company the amount of 31,902,035,179.56 VND as the remaining payment under the 04 contracts number 03 dated October 3, 2006, number 05 dated December 20, 2006, number 06 dated December 20, 2006 and number 01 dated February 1, 2007. On November 5, 2008, Hung Yen Metallurgy Company submitted an appeal. In Appellate Commercial Judgment No. 32/2009/KDTMPT, dated February 19, 2009, the Appellate Court of the Supreme People's Court of Hanoi ruled, 1. To set aside First Instance Commercial Judgment No. 09/2008/KDTMST, dated October 23, 2008 of the People's Court of Bac Ninh Province on dispute on contract for sale of goods between Hung Yen Metallurgy Company and Vietnam, Italy Steel Company. 2. Transfer the case to the First Instance Court for resettlement, for the reason, the General Director being Mr. Tran Van Vi only initiated a lawsuit to claim the amount of 12,874,298,683 VND from Hung Yen Metallurgy Company, but the authorized representative had amended and supplemented the claims continuously, which exceeded his authorization and was in violation of Article 164.2.1 of the Civil Procedure Code and Resolution No. 02/2006/NQHDTP dated May 12, 2006 of the Judicial Council of the Supreme People's Court. All the applications for amendment and supplementation of the claims of the authorized representative were not in compliance with the law, and that the First Instance Court accepted all claims of the authorized representative was a serious violation of the civil proceedings. Thus the Appellate Court did not review the contents of the appeal in respect of Hung Yen Metallurgy Company. In First Instance Commercial Judgment No. 18/2009/KDTMST, dated September 3, 2009, the People's Court of Bac Ninh Province ruled, 1. To compel Hung Yen Metallurgy Company to pay Vietnam, Italy Steel Company the total amount of VND 28,145,956,647 as the remaining payment under the 04 contracts. Contract number 03 dated October 3, 2006, contract number 05 dated December 20, 2006, contract number 06 dated December 20, 2006 and contract number 01 dated February 1, 2007 and issue VAT invoices to Vietnam, Italy Steel Company for the amount of VND 21,544,992,000 in regard to contract No. June 2006 and an amount of VND 30,469,842,000 in regard to contract No. January 2007 inch. In addition, the First Instance Court ruled on the court fees, the enforcement, and the right to appeal of the involved parties in accordance with the law. On September 23, 2009, Hung Yen Metallurgy Company submitted an appeal. In Appellate Commercial Judgment No. 63/KDTMPT, dated April 5, 2010, the Appellate Court of the Supreme People's Court of Hanoi ruled, to set aside First Instance Commercial Judgment No. 18/2009/KDTMST, dated September 3, 2009 of the People's Court of Bac Ninh Province. Transfer the case to the People's Court of Bac Ninh Province for resettlement in accordance with the law. On July 25, 2010, People's Court of Bac Ninh Province issued Official Letter No. 110/2010/CVTA requesting the Chief Justice of the Supreme People's Court to reconsider the appellate judgment by following cassation procedures. In decision on Appeal No. 17/2012/KDTMKN dated June 25, 2012, the Chief Justice of the Supreme People's Court requested that the Judicial Council of the Supreme People's Court to conduct the cassation procedures to set aside Appellate Commercial Judgment No. 63/KDTMPT, dated April 5, 2010 of the Appellate Court of the Supreme People's Court of Hanoi, transfer the case to the Appellate Court of the Supreme People's Court of Hanoi for settlement following appellate procedures in accordance with the law.
Part 4. Assessment of the Court.
From October 2006 to February 2007, Vietnam, Italy Steel Company and Hung Yen Metallurgy Company entered into 04 economic contracts, number 03/2006/HDKT, dated October 3, 2006, no May 2006 HDKT, number 06/2006. HDKT dated December 20, 2006 and no January 2007 HDKT dated February 1, 2007. At the time of the signing of the contracts, with respect to Hung Yen Metallurgy Company, Ms. Luti Nak Lon was still the legal representative, pursuant to the Enterprise Registration Certificate with Fifth Amendment dated August 12, 2005 and Sixth Amendment dated July 6, 2007 of Hung Yen Metallurgy Company and Decision on Changes of Business Registration No. 140/QDHDCD dated July 2, 2007 of Hung Yen Metallurgy Company. Under Power of Attorney No. 621/UQKKHY dated September 10, 2005, Ms. Lon had 1. Authorized Mr. Nguyen Van Tin to manage and operate Hung Yen Metallurgy Company. 2. Mr. Nguyen Van Tin shall be responsible for representing the company in relations with the banks, organizations, individuals and other involved units to ensure the normal operation of the company, on behalf of the company, performing civil, economic and commercial transactions within the business lines of the company. On November 20, 2006. Ms. Lon issued Power of Attorney No. 1296/UQ/HYM empowering Mr. Le Van Man to manage and operate the company. Contents of the authorization were the same as those for Mr. Tin. It was lawful that Ms. Lon issued the aforesaid Power of Attorney in favor of Mr. Nguyen Van Tin and Mr. Le Van Man, who were deputy directors of the company, to sign those economic contracts. The fact that Mr. Tin and Mr. Man, on behalf of the company but not themselves, signed the contracts leaves them to have no related rights and obligations in this case. As a result, it cannot be determined that Mr. Tin and Mr. Man are persons with related rights and obligations in this case as requested by the defendant and opined by the appellate court. The fact that the appellate court based on the agreement on division of property during marriage between Ms. Luti Nak Lon and Mr. Le Van Dung and the debt commitment document of the company between Mr. Le Van Dung and Ms. Nguyen T Ton to state that Mr. Dung, Ms. Lon and Ms. Ton are persons with related rights and obligations is not correct. That is because, the agreement on division of property during marriage was between Mr. Le Van Dung and Ms. Luti Nak Lon, and that Ms. Nguyen T Ton and Mr. Le Van Dung had an agreement on responsibility in paying the debts was an internal matter of Hung Yen Metallurgy Company. The debt commitment made between Mr. Dung and Ms. Ton had not been accepted by Vietnam, Italy Steel Company being the party having related rights. Pursuant to Article 315.1 of the Civil Code 2005, the obligor may transfer a civil obligation to a substitute obligor, if the obligee consents. During the dispute settlement, Mr. Dung and Ms. Lon gave clear statements on their agreement on division of property during marriage, the signing of contracts with Vietnam, Italy Steel Company. Responsibility of Hung Yen Metallurgy Company in performing the obligations in the contracts. Mr. Dung also requested to be absent from the court hearings. Therefore, that the summons of Mr. Dung and Ms. Lon to give testimony and be cross-examined as requested by the appellate court is not necessary. As a consequence, it is not lawful for the appellate court to set aside first instance commercial judgment number 18/2009/KDTMST dated September 3, 2009 of the People's Court of Bac Ninh Province and transfer the case to the People's Court of Bac Ninh Province for resettlement. As to the contents, during the contract performance, Vietnam, Italy Steel Company remitted money via bank wire instructions to Hung Yen Metallurgy Company. Hung Yen Metallurgy Company delivered the goods to Vietnam, Italy Steel Company, proved by minutes of goods delivery duly stamped by Hung Yen Metallurgy Company. According to Article 93.1 of the Civil Code 2005, it is provided that a legal person shall bear civil liability for the exercise of its civil rights and performance of its civil obligations established and performed by its representative in the name of the legal person. Therefore, in this case, Hung Yen Metallurgy Company shall be responsible for paying the debts to Vietnam, Italy Steel Company. Since Hung Yen Metallurgy Company failed to fulfill its commitments as agreed in the contracts, i.e. failure to deliver sufficient goods to Vietnam, Italy Steel Company, there is sufficient basis for Vietnam, Italy Steel Company to initiate a lawsuit against Hung Yen Metallurgy Company to request Hung Yen Metallurgy Company to return the received money, corresponding to the undelivered goods, the overdue interest for late payment, penalties for breach and compensation for damages, due to the non-delivery. Vietnam, Italy's steel company had to purchase the goods from other sellers at higher price than that of Hung Yen Metallurgy Company, which is in accordance with Article 34, Article 297.3, Articles 300, 301, 302, 306 and 307 of the Commercial Law 2005. However, the first instance court made an incorrect calculation as to the amount that Hung Yen Metallurgy Company is obligated to pay Vietnam, Italy's steel company, in particular. As to the advance payments with regard to the undelivered goods in the 4 economic contracts, the first instance court had correctly calculated the correct amount of money that Hung Yen Metallurgy Company had to return Vietnam, Italy's steel company. However, as to the overdue interest on the aforesaid amount, although the first instance court applied Article 306 of the Commercial Law 2005, it did not apply the average overdue interest rate on the market of at least 3 local banks at the time of payment, at the first instance hearing, to make the calculation. Instead, the first instance court was wrong in applying the basic interest of the state bank at the time of the first instance hearing at the plaintiff's request to determine the overdue interest, being 10.5% per year. In this case, the court needs to apply the average overdue interest on the market of at least 3 local banks, Agribank, Vietcombank and Vietinbank, to calculate the overdue interest in accordance with the law. As to penalties for breach, both parties agreed that Party B shall be subject to a penalty equivalent to 2% of the value of the approved shipments when Party B commits one of the following breaches, either failure to deliver conforming goods, or failure to deliver the goods. As such, Hung Yen Metallurgy Company, since Hung Yen Metallurgy Company failed to deliver sufficient goods, it shall pay a contractual penalty equivalent to 2% of the value of the breached contractual obligation portion to Vietnam, Italy's steel company in accordance with Article 300 and Article 301 of the Commercial Law 2005. There is a basis for the first instance court to accept the claim for penalties for breach of Vietnam, Italy's steel company. However, calculating interest over the penalties for contractual breach is not correct. As to the compensation for damages, according to Vietnam, Italy's steel company's submissions, it was because Hung Yen Metallurgy Company breached the contracts for not delivering sufficient goods. Vietnam, Italy's steel company had to purchase steel billets at higher price from other manufacturers to ensure the continuity of the production and business of the company. The first instance court relied on only the contracts for sale of steel billets which Vietnam, Italy's steel company signed with other manufacturers to compel Hung Yen Metallurgy Company to pay Vietnam, Italy's steel company the difference in value due to the purchase of the substitute goods at higher price. But the court failed to determine whether the purchase of substitute goods from other manufacturers would serve for the purpose of substituting the undelivered and insufficient goods from Hung Yen Metallurgy Company to ensure the continuity of the business operation as planned. In this regard, the court should have requested Vietnam, Italy's steel company to submit documents, evidence, such as goods orders from third parties, production and business plan, to prove that the actual damage had occurred, and from that there would be a basis to compel Hung Yen Metallurgy Company to compensate the damages in a proper manner. Besides, the first instance court's calculations of interest on the damages are not compliant with Article 302 of the Commercial Law 2005. In light of the aforementioned reasons, pursuant to Article 291.3, Article 297.3, Article 299 of the Civil Procedure Code, amended and supplemented in 2011.
Part 4. Assessment of the Court. Part 5. Rules.
To set aside Appellate Commercial Judgment No. 63/KDTMPT dated April 5, 2010 of the Appellate Court of the Supreme People's Court of Hanoi and First Instance Commercial Judgment No. 18/2009/KDTMST dated September 3, 2009 of the People's Court of Bac Ninh Province, to transfer the case to the People's Court of Bac Ninh Province for resettlement in accordance with the law. As to the advance payments with regard to the undelivered goods in the 4 economic contracts, the first instance court had correctly calculated the correct amount of money that Hung Yen Metallurgy Company had to return Vietnam, Italy's steel company. However, as to the overdue interest on the aforesaid amount, although the first instance court applied Article 306 of the Commercial Law 2005, it did not apply the average overdue interest rate on the market of at least 3 local banks at the time of payment, at the first instance hearing, to make a calculation. Instead, the first instance court was wrong in applying the basic interest of the state bank at the time of the first instance hearing at the plaintiff's request to determine the overdue interest, being 10.5% per year. In this case, the court needs to apply the average overdue interest on the market of at least 3 local banks, Agribank, Vietcombank, and Vietnambank, to calculate the overdue interest in accordance with the law. There is sufficient basis for the first instance court to accept the request for penalties for breach of Vietnam, Italy Steel Company. However, calculating interest over the penalties for breach is not correct. That the first instance court calculated interest over the damages is not compliant with Article 302 of the Commercial Law 2005.